Hello there. So you find yourself in the IP protection gaming webinar. In the course of next 30 or so minutes, we will go through a number of forgotten mysteries that will help you out actually in the creation of your next video game. I'm Majo, the CEO of Sparring, but more importantly, the legal and growth wizard. And together with my colleagues, we help dozens of innovation companies, gaming studios, startups from the CEU in their global scaling. IP is my favorite topic, so I'm glad you are watching this video, and please bear with me. I'm sure the stuff we'll be covering today will be useful for you and your future projects, even maybe current ones, well, whatever. Let's get started. So why IP? Well, gaming studios are amazing. They bring together software engineers, artists, creativists, composers, and other roles that create a unique content. It's music, it's visual, it's source code, it's gaming rules, it's so many things that actually can have zero value if they are not protected. And they can be used by the pirates, by the free riders, by your competition, or anybody else. So therefore, if your content has to have some value, and if your content is supposed to be sold, it has to be protected. And there are 4 ways of protection: the copyright, patents, trademarks, and trade secrets. We'll go through all of them in the next slides. The good protection of IP is also important for your strategic partner or joint venture member or investor or anybody actually who will cooperate with you. So even if as a gaming studio you are raising some funds, then the IP is a must. So any due diligence we'll go through will be focused also on the IP protection. So bear this in mind and be very vigilant when it comes to the protection of this. Well, I mean, of course, it's when it comes to the timing of the protection, it's always to be active, not to be passive. If you're passive, then you can very often find yourself in a courtroom, having a dispute, which cost you money, cost you time. It's defocus. So it's really important for you to be proactive and try to protect the stuff you create. It's always good to do it at the very beginning of the project and in the course of it. But of course, sometimes it's not efficient. It's not possible for whatever reasons. And therefore, you should do it as soon as possible. However, the different rules apply for copyright, different rules apply for patents, and we'll go through them also in the course of this presentation. Good, so that's for the outset. And now let's get really into it. So copyright is the first possibility how to protect your intellectual property. So what does copyright covers? Well, copyright doesn't cover your idea. Ideas, since it's hard to know what you think, it's hard to protect it. However, when it comes to the artistic or creative expression, meaning a music, a drawing, source code, manual, game rules, whatever, such things can be protected. The good, and actually copyright is my favorite, very close to my heart. The good thing about copyright is it does not need to be registered. In US, it's possible, of course. It costs you a few bucks. But in general, the copyright does not need to be registered. The protection basically becomes efficient at the very moment of the creation of the work, of the masterpiece. However, there are certain tweaks we have to cover. What's very important when it comes to the copyright is you have to distinguish between moral and proprietary rights. The moral rights usually rest with the author, so it's like right to name the particular game or to say when it should be published, and the proprietary rights relate to the business rights. So in relation to the publishing, to the copying, to the licensing, lending, selling, whatever. And in most of the continental Europe countries, only proprietary rights can be actually transferred to the third parties, whereas the moral rights only stay with the author. Whereas in the Anglo-American countries, it's possible to transfer both moral and proprietary rights. So first of all, be aware of this difference. What's very important is that in some countries, the author can only be a natural person, so like a flesh and bones person, right? Whereas, so the company can only be an author, which is tricky when it comes to the moral rights. However, in some countries, mostly again Anglo-American countries, the author can also be a legal entity. So, for instance, the company that bears name of your gaming studio. So it really depends in which jurisdiction you operate. Depending on your jurisdiction, um, uh, it depends who the author of your work should be. Why is that important? Because if only natural persons can be authors, then you need to obtain the IP from them and transfer the IP from your authors to your entity so that your entity can actually really sell it to your clients, to the gamers all around the world. Uh, what's really important is that if you really would like to sell your games, your clients, the gamers, are on one side, the author on the other, and the IP chain needs to be complete. There cannot be any gaps. It's impossible to sell to your clients a game if your company doesn't own it. So therefore, as I've said, the IP line has to be complete, and you should be really thoughtful about it. What's really important, if you register the copyright in the US, then you can put the C in the particular, usually the phrase or some kind of drawing or symbol. Okay, the protection of the IP is pretty long. I mean, the games are important for a couple of years. The copyright usually lasts for 70, so you shouldn't be afraid of that. But as I've said, what's really important when it comes to the copyright are the IP transfers. When it comes to the IP transfers, usually those are done by a license agreement. Those are There are a number of features of the license agreements. So first of all, it's either exclusive or non-exclusive. If you're getting the IP from your authors or the designers, game developers, composers, it's important to obtain exclusive license so that only your company can really manage the IP. However, when you are selling the particular game you create, then of course the license has to be non-exclusive. The tricky point is with the publishing houses. If you cooperate with a publishing house, then very often the publishing house wants a exclusive license, and you should really fight back so that you will have more options open, especially in the case if the cooperation with the particular publishers does not go very well. Also, the license should be either for the consideration, so for money, or it can be free. And also it can be limited or unlimited. And when it comes to limitation, the limitation can be in time, in the particular territory, state, country, whatever, which usually depends again. With the publishers, it can be limited to the particular country. There are some publishers strong in Europe, some of them are strong in Northern America, so it really makes sense to distinguish which territory would be allocated to which publisher. Again, also there are certain other regimes, especially if you are developing the games with external partners. So for that, you need to think about also some specific legal regimes for work for hire, joint work, but that's rather complex. And if you really develop the game with the third party, so with the external development house or whatever, then you should really have some lawyer on board to help you out. However, if you have just only in-house development of your game, just be mindful that you need a written agreement with every single member of your team contributing to your game. Those agreements should have this IP transfer clause so that the IP would be exclusively transferred from them to you. That's the rule number one. You should always remember it. I've seen so many startups and studios that who actually, yeah, those were friends. We don't need any contracts. But then without contracts, there is no the IP transfer very often. It's ideal soil for a dispute. Therefore, please bear in mind you should have agreements, especially within your own team. When it comes to the publishing deals, well, first of all, it's always good for gaming studio to partner with a publishing house because such publishers can help you out with the sales, with the marketing, with the stuff they do, with the stuff they're good at. However, there is a huge power imbalance because they deal with the hundreds, if not thousands, of the game developers, and therefore their negotiation position is very strong. However, even with dealing with the strongest ones, you should always be aware of the fact of the stuff that's vital for you. For instance, the IP. Also, it's very important for you to not to be exclusive. So it's the worst thing ever to sign a partnership contract with a publishing house that is exclusive and actually don't have any possibility to withdraw from it or to actually appoint another publishing house somewhere else. So do not get yourself locked in the contract with one publisher, and especially if it's your first game. I mean, of course, if it's a lasting relationship, you have like 5 games together and all of them was a success, then of course some trust can actually be able to advocate some lock-in mechanisms. But in general, it's very important for you to have backdoors and options open so that you can steer the sale, marketing, and promotion of your games. Cool. So this was the copyright. Now we move to patents. Patents, I would say, the most complex stuff. Very few gaming studios need to get the patent. It takes very long. It costs a lot, and might not be that efficient for your business. So copyright is much more efficient in this way. However, there are some gamers or gaming studios that were able to register the patent, and it helped them out. I will go through the cases a bit later on. So what's really important is that the patent is related to the real inventions. It's either it's either the gameplay method, or it's related to the hardware. Usually, it's the hardware stuff, but also it can be some kind of user interface artwork or ornamental design, icon, character, whatever. But usually your case is much stronger when it comes to the gameplay method or especially the hardware technical solution. It has to be novel all across the whole world. So if such technical solution exists already somewhere else in some different country, then your patent would not be registered in the second country. So it's really important to be the very first to use it, to invent it, so that you can register it. Otherwise, it can. If you're the second, then you have no claim on it. Also, as I've said, it's very time-consuming and expensive, and there is some protection period depending on the country. Usually, it's 10 to 20 years. Usually 20. It can be renewed for one time, but yeah, doesn't really make sense for the games. What's really important is that you should first go for copyright. You should also go for trade secret. You should also go for trademarks. Really be aware whether you should go for patents. Pokemon Go and FIFA went for the patents, and FIFA was successful in patenting this special map identifying the football players on the screen. Pokemon Go was able to patent the appearance probability of Pokemon characters due to the daytime and also the frequency of particular characters. So this algorithm was patented. But you have to be also rather certain that the stuff you try to patent really helps your business. If it's not essential for your business, then maybe it's not worth it. So you should really do some value for money approach, so that you would know whether it makes sense for you or not. As I've said, this is rather rare. So if you are undecisive, then I would suggest it's not really worth it. Cool. Now trademarks. So this is my favorite type. So trademarks pretty much protect your brand. So it's company name, logo, game title, some symbol or design. It's about making your brand recognizable and protected, so that the consumers, meaning your clients, would not be misled or not be confused when seeing some similar logo of different game. The process, trademarks need to be registered. There is this official process, which is significantly faster and cheaper than the patents. There are online services that enable you to do the trademark registration couple of clicks and minutes. The cost differs from country to country, from €100 or hundreds of euros to thousands. Very often, gaming studios go for the European-wide trademark, which costs around like thousands of euros, and then for the US. Once you covered US and EU, usually for the start, you are okay. But of course, if you are strong in some particular markets, such as South Korea or elsewhere, then of course you should also go for their trademarks as well. The trademark, you would know that somebody is registered as a trademark if there is this little R in the circle. The TM stuff means that you actually filed the application, but the trademark was not registered yet. The broader protection you seek, I mean, the more countries you apply for, the more conflicts they may arise, because the trademarks, it's not about being the same, but even similar trademarks can actually, and existing trademarks and holders of the trademarks can oppose your registration if it's in the same category of the services, which is gaming, and looks or is pretty much similar or can confuse the consumers. So before you do the registration, you can check the existing trademarks, and you can consult your attorneys, and you can see, or you can do the, I mean, the check is not that difficult, so you can do it usually on your own. You can see whether there are potential conflicts or not. If there are many conflicts, I've seen ones like 160 conflicts or so in the US, then probably you will have some problems and you might not be registered. However, if their conflicts are only a few, then even if you file a trademark and you get some opposition from the holder of the conflicting trademark, then you can usually be able to solve the situation within a couple of emails if there is a goodwill from the both sides. Yeah, a good service for the registration of the EU and US trademarks is this traumatm.com. Go check it out. It's pretty user friendly. And it's also, yeah, it's provided by Sparring, because we really try to help people out as much as possible when it comes to the legal hurdles and jungle and whatever. Cool. So these are the trademarks. The last topic when it comes to the IP protection is trade secrets. The trade secret is tricky, right? It's usually it may algorithm, it can be notes on the game, pricing, customer mailing, the strategy, the plan of sequels. So many things that go, especially in relation to the strategy of the particular development studio or the gaming studio. To protect those, it's hard. Usually, those are not breached by the foreign espionage. Usually, those trade secrets are abused by the bad leavers from your company, your former team members. The best ways for you to protect yourself is either to go, oh, first of all, it's always a must. It's a good standard practice. You should sign the NDA with every single person working with you should be covered by the well structured NDA to begin with. Also, what's really important is I would say, everyday routine within the team. So not every single person within your team should have access to all the information. So it's very important for you to know what are the access rights, what are the levels and the roles within your team, and each particular member of your team should have access only to the files and notes and content that's necessary for him or her to work with. So you should be able also to make these processes in place when managing the development of your portfolio games. Uh, Also, what might be possible for you is the anti-competition or non-compete clause in the agreements with your employees or team members. However, those are usually not that efficient. And in some countries, it's even not possible to include them into the agreement. It's too harsh to basically forbid the game developer to work for different game development studio. Um, so we've seen a couple of situations like this. However, this is not I would say the usual market standard. Um, However, you can again, especially with the NDA, with the penalties and liquidated damages, you can always actually prevent such trade secret abuses from happening. Good, great success. We did it. So it was everything for me. As I've said, IP for the creatives, for the people who create content that they will to sell, it's important. It's important to protect it. If it's not protected, it's basically it's valueless. Uh, so in order to make it valuable, please protect it. There are a number of ways. It's a good start for you to go for copyright, then for trademarks. It's always good to have these trade secret protection mechanisms in place. Think twice if you would like to go for patents. And most of all, yeah, I wish you best of luck in creating the world best games that will make people a better time. So thank you very much, and I hope you learned something new that will help you out in future. Thank you very much.